What's up, co-counsels? I am exhausted. Okay, I'm beat. I'm really, really tired, but I'm here. Hopefully, you guys had a great week. I've been parenting. I've been working, reviewing medical records. I'm tired. But let's get it. I almost did not come up here, but I'm like, nah, I promised my co-counsels. So I'm trying to be consistent. In any event, let us get into it, okay? We're going back to last week, all right? We're going back to last week. There was no court today. My understanding, according to Vinny, court is ahead of schedule. So for that reason, Bev Cannone decided to give the jurors, I suppose, an extended break because they're off tomorrow because of Memorial Day, and they're off. I mean, they're off on Monday because most people are off on Monday. And then Tuesday, I don't remember if court's in session on Tuesday or not. I think they're off on Tuesday. I don't quite remember. So I suppose folks can travel and go about their business. Yesterday's proceedings were a little concerning though, because what is today, Thursday? Yeah, yesterday. Yep, you're right. So on Wednesday, the proceedings were a little concerning. What I mean by that is Bev Cannone questioned the jurors individually. I don't want to know is a questioning, interviewing, whatever it was. But she called. Okay, so Brooklyn said back on Tuesday. So jurors were questioned individually yesterday. All right. Cameras were cut off, so nobody apart from the attorneys and the defendant, and obviously the court reporter, nobody actually knows what the interviews were about or what the questioning was about. Um, Initially, what I was speculating, I was of the opinion that it must have something to do with court procedure in terms of duration or timing. That's what I was thinking. Today I listened to a bit. Was it today? Yeah, it was today. I listened to Vinny. I listened to Vinny a little bit on Court TV, and there are some other speculations. Apparently, two jurors, um, when the court reporters returned to the courtroom, they realized that two jurors were no longer sitting in, I'm not going to call it assigned seats, but they'd kind of switched where they'd ordinarily sit. So I don't know if that's coincidence or if that had anything to do with the questioning, but those were some of the speculations. And then there's further speculation that there's a possibility that jurors got into stuff they should not have gotten into, and possibly somebody alerted or reported this to the court to the point where they had to question everybody to not, maybe point a specific juror out. So we don't know how that's going to play out. If in fact there's anything to it, we don't know if they're going to, um, if they're going to be dismissed so they don't deliberate. I don't know what's going on, but there's a lot of speculation. In any event, last Friday I did not watch the proceedings, but I do want to catch up to all the Karen Reed. I don't even know what to call them. The tapes, the confessions. I don't know what to call them. So, yeah.
Cannone, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts.
Hello,
Court is now
girls should
open.
be in
You may
bed,
be
but
seated.
we got home pretty late. What
Good
have you been
morning
up to,
again,
Brooklyn?
Council. Good morning again, Ms. Reed.
Good morning.
Good morning, jurors. So I appreciate your patience. I have to ask you those three questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone said yes and nodded affirmatively. Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday?
No.
I have one other important instruction for you folks, and it's so important that each and every juror can hear the evidence or the testimony that's presented, can follow the testimony, and can understand and evaluate the
What's wrong,
testimony of
Cannone?
each witness and the exhibits. In order to do that, I just want to be very clear that it's important that people do not comment on the evidence or make any comments. Once you enter the room, it's probably a good idea to just think.
Okay, so it sounds like some jurors may have been animated during the presentation of the evidence.
Listen, don't talk.
What's this up
Don't
here?
make any facial expressions, no muttering under your breath, no audible noises, because people need to hear what's going on and to understand everything. So out of respect for your fellow jurors, I would ask that you be very
Sounds
careful
like
to
somebody
make
has
sure
been
you
up
don't
to
do that.
something.
And out of respect to the lawyers who worked so hard to get this case before.
Okay.
Thank you very much. With that, Mr. Brennan, your first witness, please.
Or if I could begin by,
Oh, I'll be live in the morning, by the way. We have to talk about Diddy because Diddy's case is actually, the prosecution's case is taking some shape, okay? Every here and there today, I tuned into Law and Crime, and they were talking about the testimony from somebody that worked for Diddy. It was a recap I listened for, I don't know, maybe 5 minutes or so. It does sound like the prosecution's case is gaining traction. So we're definitely talking about Diddy in the morning.
offering a stipulation that's agreed to between the parties.
Okay, can we turn the AC down, please?
Dang, you freezing? I'm tired.
Thank you.
Yes.
Your Honor, if I may, I'd like to read a stipulation agreement between the Commonwealth and the defense.
Okay.
And the stipulation between the parties is as follows. Now comes the Commonwealth and Karen Reed, the defendant, in the above captioned matter. Both parties respectfully stipulate to the following.
Okay.
The two Massachusetts State Police troopers present at the autopsy conducted by the medical examiner, Dr. Scortibello, on January 31st, 2022, were Trooper Keefe and Trooper Watson. Former Trooper Michael Proctor was not present.
Okay.
Thank you.
And
Yes, thank you.
with that, Your Honor, I'd like to introduce and play.
Okay. Hold on. So I'm trying to figure out what led to this stipulation. We're going to have to go back to prior testimony. Yeah, we're going to have to go back to prior testimony.
Clip number 21.
Okay, Paul, turn the AC off. Hold on one
Okay.
second, please, I just want that.
What's happening?
Can the jurors hear better with that on?
Happening.
So John's laying there on his left and his right, and I approach John from the left. So
Hold on.
John's laying there on his left and his right, and I approach John from the left. That's where the street is. And he had a piece of glass, like perched.
Woman, man, TV camera. What on earth is going on here? This is this move, this press run. I do not understand. I don't get it. I do not get it. I really don't get it.
On his nose, like just wedged like a splinter would be. And I just pulled it. And as soon as I
And
pulled
what I
it,
was wondering, here's a thought, okay? What I was thinking about as far as the Commonwealth's case, because right now, not that it makes a difference, but my understanding is that the Commonwealth got the not published, but they got hold of the documentaries as they aired on TV, but they also got the unedited footage, or at least parts that producers were specifically told to take out by defense. So I've always wondered if the prosecution is going to call one of these producers. Probably not, right? The reason, because I'm working through it right now. I've wondered if they're going to call one of these producers or the interviewers to the stand to talk about the statements that Karen Reed made. And the only reason I'm interested in that is to the extent of what was in the final, or what aired in the final documentary, and what did the defense want out. That's really what I'm interested in. So but probably not, because the defense is probably going to argue that it's bolstering, and the judge is probably going to agree with that, because we do have the tapes themselves, and then the defense is probably also going to argue best evidence rule. So yeah, but I'm just curious. I'm curious, but this defense move, I have no idea. I don't understand it. It doesn't make sense to me. It's just it's
It just gushed blood down his face.
I need
As
to
soon as I
check
enter-
that.
So,
It sounds like she got out the car.
so John's laying there, his left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face.
That's just insanity. that will never make sense to me. That will never make sense to me. This defense move does not make sense to me. What's up, Alice
You can
girl?
have the item.
All right. So Brooklyn's getting ready for a wedding. Is that your son's wedding? Brooklyn says 2 jurors are supposedly shaking up and getting too close with each other. Okay, so it sounds like, so it must be the 2 that were moved in, because apparently, according to it's not Law and Crime, Court TV, 2 jurors had actually shifted positions. Okay. And then that's according to Turtle Boy. I don't know about Turtle Boy, though. I don't know about Turtle Boy. I just, because wasn't it a few weeks ago where they charged him with something? I was going to look into it, but I'm like, girl, leave Turtle Boy alone. What's up, Big Allie? Shout out to Allie, okay? Brooklyn said Gretchen Barr's Dateline is on the list. Is on the list for the Commonwealth. They're not sure if they're actually calling her. That's actually fantastic. And this is how you guys know I'm not a fake lawyer, okay? I'm not a fake lawyer, because even going back to Diddy a little bit, it's my understanding, I don't know if it was today or yesterday, but it's my understanding that they actually called the government called some type of expert, therapist, psychologist, somebody along those lines, to testify as to why victims stay. And that's the one thing that I mentioned or considered the last time we talked about Diddy. I don't even remember the last time we talked about Diddy. Was that yesterday? Yeah, that was it? I think it was yesterday. I don't remember. My days are a blur. All right. But let's fast forward. We want to get into the attorneys getting a little tricky. Okay. Let me see if I can find it.
Photographs, do you recognize those?
I had a timestamp. I had a timestamp. I think it's here. I think it's here. I really cannot wait for this Brian Kohlberger case. Yeah. It's just, I don't know. Oh no, the defense has a difficult case in that one. All right, come on.
You are unmuted.
Okay.
Thank you, Your Honor. Yesterday, Your Honor discussed with the parties, and parties were heard with regard to the issues we have raised with regard to the timing of the May 8th report from Mr. Burgess that the defense received on May 11th.
Listen, they were freaking out. Mr. Burgess is probably the best thing that has happened to the defense so far. They were freaking. I mean, this is, obviously they did not know that Mr. Burgess would be problematic and he would cite qualifications he did not have and even qualifications that do not exist. So
11. And what I wanted to do, Your Honor, is briefly provide the information Your Honor asked for yesterday, which was how much time we might need under various circumstances.
Okay.
And so I wanted to take a few moments to put that in context. It will only take me a brief amount of time to do so. So, Your Honor, there is a timing issue, but there's most importantly a substantive issue. I will not, of course, go into the detail of yesterday, but the timing really is informed by the substantive issue. And so with regard to the matter, we went back and we looked at more deeply the effect of this timing and this movement of the what has been referred to as clock drift in Mr. Burgess's report that we got on May 11th. I spoke of the significance yesterday, and here's what I would like to add as is relevant to the time we're going to need. I again urge the court to reject it substantively, because what we did was we went and we looked at matters such as the cross-examination of a key witness in this case, Jennifer McCabe. She testified with regard to observing a vehicle at 12:45 a.m. And that's a significant point. I know I don't need to elucidate for Your Honor. All of this is going in significant part, if not total part, to what has been as alleged a collision here, which we vigorously contest. It just no collision ever occurred. But the timing of it, the timing of what's alleged by the Commonwealth is very important. The seconds are important. Literally 1 second can turn not only
all right, come on, Alessi.
the Commonwealth's theory completely around in circles and debunk it, but also the jury's analysis.
I forgot. There's no way you never got my email, though. I'll take a look at it now.
Of it. And this is the point I wanted to elucidate today, is that the jurors have been provided information and the defense has aimed its defense on this claim based upon, in large part, timing. So now what we have is on May 11th, Mr. Burgess changing the timing. So what does it affect? Not only witnesses like Jennifer McCabe, who we strategized with regard to, but also my decision to not even cross Trooper Garino, because Trooper Garino had testimony with regard to when Ms. Reed connected with the Wi-Fi at One Meadows, and there's a certain time associated with that. We have Mr. Whiffen, who went through, the Commonwealth went through a timeline, and we believe they went through a timeline for the theory that they had.
There is no way you did not get my email, because I don't have anything in draft. In fact, I still see my email, though. I'm just going to forward it to you. I'm going to forward the email to you.
And I cross-examined Mr. Whiffen extensively with regard to that timeline. There were several defense strategies, and effectuations of strategies based upon that timing.
I just forwarded the email to you again.
With regard to the substance, Your Honor, and there's more, but I think that's a fair.
It's my reply to the email you sent me with Lori Vallow-Daybell.
Representation. It innervates our entire defense. The question now of Your Honor of how much time it will take the defense to react to Mr. Burgess. I wanted to say it's not only a reaction, but it's a substantive defense analysis, and 3/4 of the effectuation of that has already occurred through our presentation.
I like Alessi, but he is so long. He is long-winded. Come on
in
now.
terms of cross-examination.
It's a full
So
stop.
we would
It's a
have
full-
to, and we're still evaluating that, revisit all of that. And secondly, we would have to put that into the calculation of all of our witnesses that we've already prepared that are based upon that timeline. So it is a very significant point. And to the extent that the Commonwealth tries to argue, well, you know, we never really committed that much to a certain time period. I again urge the court to look at the report of Dr. Judson Welcher, where he has 1162-2 with a specific range, 38 to 43. And even in their range, it's a very small time, which further supports how each second matters in this regard. Now to the answer to the question Your Honor asked
So you're not
yesterday.
even done
Again, I
answering?
urge that it just be rejected and we keep this trial moving in its current pace. To the extent that that does not occur, and again, we urge that it be rejected, the report, because it's a Rule 14 violation, there is no remedy for the defense.
We went over that rule extensively. It's not a Rule 14 violation. Okay.
However, to the extent, and given Your Honor nonetheless asked me for an answer in time, we would need 4 days to be able to address it.
Who's this woman? I think I've asked
will
that
not
before.
ever be
Because on Tuesday, I believe she had like turquoise glasses on. or
able to
something.
recover strategically or substantively from it, given all that's been presented to the jury. And it will be very difficult to figure out how we're going to go present a defense after we've already presented to the jury our defense and our cross-examination. It's not really structurally possible to simply take 4 days and address Mr. Burgess, because we can't go back to all the witnesses I just mentioned and others and start crossing them and eliciting testimony with this new time period in mind. But I wanted to answer the question, Your Honor, respectfully. It would be 4 days for us to even go from where we are now and then try to alter not only witnesses such as Arca, but DeSogra and Gaffney and other types of witnesses that we have in that regard. So my, Your Honor, respectfully, that is my response.
All right,
Okay.
does the Commonwealth want to be heard?
Of course. And I think I've ultimately figured out why Alessi is doing a good job in this case, because typically attorneys that strictly represent I don't want to say clients, but attorneys that strictly specialize in civil cases, they often do a terrible job when it comes to criminal cases. But as I was thinking about this, I think it ultimately makes sense for Alessi to be the one that's cross-examining the experts. And the reason for that is because civil attorneys, again, it depends on the specific area, but civil attorneys do tend to have a lot more contact and interaction with medical experts. So it makes sense that he's the individual that's called upon to challenge expert testimony. What's Brooklyn saying? Brooklyn's saying that isn't Rule 14 a mental condition when someone is monitored for 72 hours to not harm themselves? No, Rule 14 is discovery. I know of in Florida, I think it's called a B32 or B13 or B30. I know it has a 3 in it. I've not heard of Rule 14 being, detention of a person that's not mentally sound. No. Maybe,
Your
I
Honor,
don't know. Maybe in your parts of the world it is, Brooklyn. I don't know.
the defense is very confused.
Woo! What on earth? Sorry. I like it when these two go back and forth. He said what?
Respectfully, Your Honor, the defense is very confused. They attempt to confuse the issue. They attempt to confuse Your Honor about what the impact would be. This has never been a change. The government is not changing their timeline. The Commonwealth is not changing any information. The Commonwealth is not offering anything that affects in any way the testimony of witnesses. It's notable in the argument there is no relationship to the facts or the actual report that was provided.
Okay.
The Commonwealth has always provided the data, which they have, and they hadn't a chance to analyze. And the interpretation of the data has been different between the parties. We have been clear from the beginning at the time in which the infotainment system shows that there was a collision. We've been clear. And the data has been clear. That has never changed. That data in the telestream system is based
You said
on
the
a
defense
clock
is
in the
confused.
Lexus, which both sides know full well is different than a clock in an iPhone. You can see all the productions of Dr. Welch's PowerPoint presentation where it shows that time, 12/31/43, has never changed.
Okay.
Also, it has been clear that both sides appreciate that there is a variance between the clock in the Lexus, which leads to that system information, and a clock in an iPhone. In fact, the defense was so aware of it, they hired an expert, Mr. DeSorga, who gave his opinions about that variance. We have never suggested there was not a variance in this case. In fact, we have highlighted the variance. When their expert, Mr. DeSorga, provided a report, we believed that his analysis was wrong. And so we looked at the variance and the data that was available from the telestream system and John O'Keefe's Waze data that was on his phone that was always available to
His
all of the
Waze.
experts in both sides. And when Mr. Burgess looked at the variance at the time of a three-point turn about 7 minutes before the collision, he simply matched the Waze information on Mr. O'Keefe's
Oh,
phone
the app.
to that of the information from the telestream and saw that it was a 21 to 29 second variance. All that data was available to the defense because their expert made an improper conclusion is not our fault. This does not change the testimony of anybody. They point to Jen McCabe's text message where she said she thought she saw a motor vehicle out front that evening at 12:45. That is not consistent with the Commonwealth's timeline, but that doesn't change. That favors the defense. It does not change anything to do with ARCA. ARCA has not, as far as I've seen in any reports, ever talked about the variance, just Mr. DeSorga. And so because this is inconvenient for the defense, and because it
Inconvenient.
further focuses the variance that we already discussed and provided, isn't a reason to exclude it. It's not late discovery. It's not a Rule 14 violation. It is further analysis of information that was already provided, opinions that were already provided, and it is in response to their experts' mistake about that variance. There's nothing new here. Nothing has changed.
Okay. Oh, yes,
Go right ahead,
respond.
Mr. Leslie. The only question I had for you yesterday, for you to respond to today, was the time, so I gave you more leeway.
And
So
you're giving me more leeway, and I appreciate
go
it.
right ahead.
So, two items, Your Honor.
Use the mic.
I alluded to yesterday, and it's been a point that Mr. Brennan just made. We believe strongly, Your Honor, that at a minimum, there needs to be a voir dire of Mr. Burgess. And we believe strongly there needs to be a voir dire because we have a serious concern that the sequestration order has been violated. He has changed a very key aspect of this matter after the testimony of Mr. Whiffen, after Mr. Whiffen presenting a timeline. In his report, Mr. Burgess, his new purported report of May 8th, he references to align it with Mr. O'Keefe's cell phone. That is the essence of Mr. Whiffen's report. is anchoring in his timeline. He did a whole timeline on Mr. O'Keefe's report. And conveniently, the proposed alteration by Mr. Burgess in his report of this clock drift now makes it very, very close to fitting within Mr. Riffin's timeline and the theory of the prosecution. At a minimum, we need a voir dire to ask Mr. Burgess, why did he do what he did? Another reason for the voir dire. Mr. Brennan yesterday
He's not
said,
happy.
we were surprised to get
Not
the
happy
report.
either.
That further
cannot stand
makes
him.
great concern as to why Mr. Burgess did what he did. Lastly, Your Honor, with regard to Mr. Brennan's point, he made it yesterday and I corrected it. He said it again today, that supposedly our witness, Mr. DeSogra, made an error and that we're trying to correct an error of Mr. DeSogra. That is incorrect, Your Honor. Again, Mr. DeSogra was responding to Mr. Burgess's report. Mr. DeSogra's report is entirely saying, okay, Mr. Burgess says this, and therefore the defense says this. Now Mr. Burgess is changing what he is saying. So it is completely incorrect to say that Mr. DeSogra is trying to correct an error. That would require, again, Mr. DeSogra to change what he has done. Final point is this. There was also an issue, Your Honor, and this is extremely important with regard to burden shifting. There's not only the question of should this be allowed at all, there's not only the question of how much time the defense will need, but there's a third and important issue, and that's burden shifting. What Mr. Brennan proposed yesterday was a very irregular process where essentially the Commonwealth gets 3 bites at the apple for a problem that they caused. The problem we're talking about is Mr. Burgess changing a significant part of a timeline. Yes, there was a variance that he had, but he picked a range of the variance. He's now changing the variance. So what the Commonwealth is proposing is that our witnesses go forward, the aperture gets to wait, they come on, and then the aperture gets to come on yet again. We would.
I did not understand the Commonwealth asking me that. Are you asking me to do that, Mr.
I
Brennan?
appreciate the
I'm
clarification.
not sure what he's saying, so.
It sounds like
He is
DeBrosa
dead. Let's
or
move on.
whatever.
His name is DeSogra, yes.
DeSoder, you're suggesting that the Commonwealth suggested yesterday that he testifies first and then the aperture witnesses?
What I understood was going to happen is Mr. Brennan said yesterday that Dr. Welcher cannot come in until after.
No, I didn't understand that. I understood Dr. Welcher, Shannon Burgess, and then Dr. Welcher for everything that you folks received prior, January 31st or whatever the date was. And then potentially for all the new ARCA information that came in May 7th, that portion, Dr. Welcher returning on rebuttal for. Not that they were holding back Dr. Welcher completely. Is that correct, Mr. Brennan?
That's the conversation I had. That conversation I wasn't part of.
Yeah, I think you misunderstood that, Mr. Leslie.
So just so I'm clear, what is it?
Sir.
that the rebuttal-
Mr. Brennan, all right, this is separate, and I'd really like to give everybody a break here. What is it the Commonwealth is asking to do regarding that?
Regarding Mr. Burgess or Mr. Welcher?
Which, Dr. Welcher?
Dr. Welcher should come in and testify to his PowerPoint, all of his opinions, which address all of the prior representations and opinions of ARCA, although we still don't have any raw information, but we're ready to move forward. Regarding any new opinions, which there is over a dozen new opinions that includes testing, video, experiments, Dr. Welcher should have enough time to review, conduct his own testing, turn it over, and then in rebuttal, address limited to the new issues raised by ARCA.
That's how I understood it, Mr. Leslie.
And that's how I did also, but the question is now with the Burgess changing of the clock drift, how many times is the Commonwealth proposing that Dr. Welcher gets to come in and talk about that? Is he just going to come in and talk about it?
So you talk with Mr. Brennan about that.
Okay, so we have there are new developments in Turtle Boy. So the judge dismissed some of the charges against him, but rejected his First Amendment argument.
All right, so I'm all set for this.
There are no changes. There is no changes in the timeline. He keeps trying to portray this as something has changed. Nothing has changed. It's the exact same. He's always said there's a variance. He's been looking into the variance for a long time, and now he has found a method to show the exact variance. It's not changing. There's nothing in the reports that changes as far as the timeline. That's just an attempt to cause fear. There's nothing that has changed. We can look at the reports. It's all the same, always has been, other than now he's identified the mistake of their expert, and that led him to be able to identify the variance, which is helpful and new. And the suggestion that there's been some violation of an order, no good faith basis whatsoever.
Does the Commonwealth oppose a voir dire adjustment?
Yeah, Brooklyn, I don't know that anybody anticipated what a, just how incredible, what's his name again? Burgess might be. What I mean by that is Burgess has testified in so many cases, in numerous cases, and all the times that he testified, not a single prosecutor, not a single defense attorney, not a single plaintiff's attorney challenged his credentials. So, yeah, there's that. It sounds like he's testified so far with zero issues, and nobody actually took or paid closer attention to his credentials until he ended up in this Karen Reed trial.
Not one issue.
Yes, because it's suggesting that there's a good faith basis for it. Nothing has. Ian Whiffin's report was available to the defense and our experts months and months and months ago. The issue of variance has been an ongoing issue for months. There's nothing that triggers a change in the testimony to adopt or adapt to it. Our timeline has been the same since when we turned it over at the beginning. They cannot point to one thing that has changed between Dr. Welcher, Ian Whiffin, Jessica Hyde, or Shannon Burgess. They are just saying things without a good faith basis. In the report, show us where something has changed.
Your Honor, to inform you, Your Honor, we would like to print
I'm tired of you
the
guys.
page in the clock adjustment because what Mr.
So,
Brennan says is
yes,
correct.
and I'm happy to any information.
Thank
All
you.
right,
Change.
20 minutes.
Yeah, so,
thank you.
All rise for the court, please.
all right, break. And then maybe on a, maybe on another day, I'll tolerate or appreciate the back and forth, but I'm exhausted tonight. Let's see. When does Cannone come back with a decision? Oh, here we go.
Court is in session, please.
For today, I'm told when I spoke with counsel earlier that we are still on track.
They're
I
always
have
on
to tell
track.
you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be extra careful with your social media use. And also, I just want to remind you, next week, Thursday is a half day and Friday is a day off. All right? So
Okay.
we'll see.
You said what?
Be extra careful with your social media use. And also, I just want to remind you, next week, Thursday is a half day and
So they were supposed to be in court today. They were supposed to be in court today, at least the first half, but they took off.
Friday is a day off. All right, so we'll see you on Monday.
Please rise for the jury.
Okay, come on. Let's get into it.
So before we recess, I appreciate that council provided me with the information. Mr. Leslie, I got the 2 reports that you had that were incorporated and what the Commonwealth had given me a few minutes before, but I appreciate that it was pointed out here. We've had full argument on this yesterday and today. My findings for the record are that the defendant has not persuaded me of undue surprise or unfair prejudice by this information, and I don't find that there's delayed disclosure. Of course, all of this is ample game for cross-examination. Certainly as to what Mr. Burgess knew, what he looked at, why he looked at it, when he looked at it, why he changed his report, and violation of the sequestration order is all for cross-examination, and I will give you a lot of leeway with that, Mr. Alessi, but I'm not having a voir dire on that. Mr. Alessi, I can tell you, obviously, you've got a great facility for cross-examining on the underlying information here. You've done fulsome cross-examinations. I have every confidence you can do it here again. But if after the direct, you demonstrate that you need further time, I'll certainly hear you on that. And more importantly, perhaps, if you feel that the testimony of Jen McCabe and the others that you've mentioned is critical and that you need to recall them, I'll hear you on that as well.
Okay, so there's a
So,
possibility.
is the time, I'll certainly hear you on that.
It might be-
Facility for cross-examining on the
Hold on.
a lot of leeway with that, Mr. Alessi, but I'm not having a voir dire on that. Mr. Alessi, I can tell you, obviously, you've got a great facility for cross-examining on the underlying information here. You've done fulsome cross-examinations. I have every confidence you can do it here again. But if after the direct, you demonstrate that you need further time, I'll certainly hear you on that. And more importantly, perhaps, if you feel that the testimony of Jen McCabe and the others that you've mentioned is critical and that you need to recall them, I'll hear you on that as well. So regarding Dr. Welcher, as my understanding, the request yesterday was for, and it's been a request, I think, a few days. We've addressed it at sidebar, and I found that it wasn't the right time. Let's see how much Dr. Welcher could go through. I understand Dr. Welcher will testify in the Commonwealth's case in chief next week or so, Mr. Brennan.
Hopefully next week, if not
All right.
the day after the holiday.
And that will be for all of the material that was provided to the defendant initially, right, by the Commonwealth's discovery deadline?
Correct.
And what you're asking for is that after ARCA testifies the new information, you're asking for rebuttal, right?
Yes, limited to the new information.
All right. So I would allow under these circumstances a limited rebuttal, and we can define the scope after we hear the
Brian
testimony of
Walsh.
ARCA. So those are my rulings. Your objections were noted. I'll see everybody on Monday.
All rise for the court, please.
Okay, let's go back. So more Boston stuff. Let me take a look at this. So Brian Walsh in court for new hearing in his Merck case, jury selection, blah, 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 accused of taking out his wife, and dismembering her body in 2023, appeared in a Massachusetts court for another hearing Thursday over recent motions made in the case, all right? So let's see, I'm just trying to, here we go. So the previous hearing in January focused in large part on suspended Massachusetts State Police Trooper Michael Proctor, who led the investigation in the Walsh case, as well as the Karen Reed. Listen, Proctor, I don't know what on earth Proctor needs to do with himself. They just, I don't know, because he's definitely affected a lot of the Commonwealth's cases. All right, so according to court filings, hundreds of pages of notes and over 2,500 images for the district attorney's office are now in possession of Walsh's defense attorneys. Many of the records given to the defense team Tuesday involve Proctor, whose testimony at Reed's first trial, which ended with a hung jury, raised serious questions about police integrity. So, Proctor, I don't know. I don't even know what to say about Proctor. I'll leave that alone. All right, let's go back. I don't see anything from today, though. I see a report from 3 days ago in this Brian Walsh case. I don't see anything from today. Yeah, I don't see anything from today. Oh my goodness, Brooklyn, I'm too tired, okay? I'm too tired. I should have taken the night off, but I did not want to leave anybody hanging. So I'm going to have to call it a night just because I have to be up really early to get my girl ready for school. So I'll be live Good night, Brooklyn. I'll be up here at 7 a.m. Eastern time, okay? And then we get started with all the Diddy stuff. Shout out to the replay crew. You guys have a fantastic weekend. I recorded some videos, by the way. I've a few shorts. I think it was last night I recorded a video. I could potentially finish editing that video tomorrow, but we'll see how I feel. Either way, it will be up sometime next week. All right, folks, have a great weekend. We will reconvene early Friday. Obviously, I won't be up here tomorrow night. All right, goodbye.